On June 17, 1972, 5 men were arrested at 2:30 a.m. after a security guard reported a break-in at the Watergate. One man claimed to be a former CIA operator. These events were a part of coverage by the Washington Post and the New York Times that had actually begun on June 13, 1971, with the publishing of leaked papers from the Pentagon. In June 1973, partisan defections began with the questioning about how much did the president know and when did he know it. Yet as late as November 17, 1973, a sitting president was still maintaining his innocence with the infamous statement, "I am not a crook." But on July 27, 1974, the House Judiciary Committee passed the first article of impeachment charging the president with obstruction of justice. And on August 8, 1974, President Richard Milhouse Nixon, despite a record landslide re-election victory, became the first sitting president to resign from the Oval Office. Historians say that it was not the break-in, but the cover-up that destroyed his presidency. But the timeline reveals that to bring this moment in history, it took the combined efforts of the press, the Congress, and popular support among the American people in collusion to turn the tide of what was called a conspiracy. Today, in the popular press, most conspiracy theories are ridiculed as folly and fantasy. But in the courts, it remains a legal cause of action. In 1944, the Federal Appeals Court for the Second Circuit, in the case of U.S. v. Andolchek, stated regarding the proofs necessary to establish a conspiracy in court, direct evidence of agreement is unnecessary. Proof of such an agreement may rest upon inferences drawn from relevant and competent circumstantial evidence, ordinarily the acts and conduct of the alleged conspirators themselves. Additionally, once the conspiracy has been established, the government need only show slight evidence that a particular person was a member of the conspiracy. Of course, a party to a conspiracy need not know the identity or even the number of his confederates. And on August 7, 2014, in the case of U.S. v. Clemico, decided in the Federal District for the Southern District of New York, the court explained the 4-factor based analysis for successful prosecution of a conspiracy in court. The government may prove the defendant's knowing participation in a conspiracy through circumstantial evidence, including the defendant's association with conspirators in furtherance of the conspiracy, his or her presence at critical stages of the conspiracy that cannot be explained by happenstance, his or her possession of items that are of essential significance to the conspiracy, and finally, acts that show a consciousness of guilt, including false, exculpatory statements. And applying this methodical approach, empirically based, in preparation to present a motion after the failure of attorneys for the Merit Systems Protections Board to respond timely to a request for waiver of service of process, as required by the Federal Rules of Civil Procedure, to the Federal District Court for the Eastern District of Virginia this week to enforce the default judgment of right, mandating that that agency comply with the requirements under the provision of law codified in 5 U.S.C. Section 1221 to commence an investigation upon a finding of a prohibited practice perpetrated by a federal employee or a violation of law, and also a motion for the court to impose sanctions against their attorneys for presentment of a fraud upon the court in criminal contempt, punishable by up to 6 months in prison and potential fines under the Federal Rule of Civil Procedure 11, as well as possible professional sanction and loss of license to practice law from the Bar Association. On the evening of July 8, 2019, I attended the town hall campaign pep rally at public expense that was hosted by Congressman Don Beyer. It is well established, beyond a reasonable doubt, that Congressman Don Beyer, as well as Senator Tim Kaine, as members of Congress, had a direct association with a responsible agency that offered a lucrative federal job to an unqualified applicant who was not just a candidate for U.S. Congress, but also the putative frontrunner and the loudest voice in opposition to the incumbent congressman. Moreover, both Senator Kaine, set to ascend to the office of Vice President, and Congressman Beyer, the heir apparent to that seat to be vacated in the Senate, had the most to gain from such a conspiracy establishing a probable motive. And focused in a kingmaker congressional district that the Washington Post had determined to decide the outcome of all statewide elections with a victory margin of just 5 points, separating the contestants for the 13 electoral college votes from the Commonwealth. It is clear, beyond a reasonable doubt, that time was of the essence and the moment was ripe to achieve victory at any cost. Even Congressman Beyer, in May 2016, announced to reporters at the Washington Post, conventional wisdom says that this is a safe district, but I am not taking anything for granted. It is well established that the presence of Congressman Don Beyer and his colleague in the Senate, Tim Kaine, were at critical stages of the conspiracy, which cannot be explained by happenstance. In the absence of a conspiracy, redundant systems at the offending agency, the Merit Systems Protections Board, law enforcement agencies, and the courts could not have occurred without exertion of undue influence from agents echelons above the small unit level, as to create a situation where the underlying crime of bribery in violation of 18 U.S.C. Section 201 might still be in litigation to begin an investigation after the passage of 2 years. While responsible actors, including both Senator Kaine and Congressman Beyer, continue to deny culpability under solemn oath in courts of law. Litigation that has received scant attention from the liberal press. It is well established with regard to their possession of items that are of essential significance to the conspiracy, only undue influence in violation of 18 U.S.C. Section 206 from the congressional offices of Congressman Beyer and Senator Kaine can explain why an internet troll operating in violation of both state and federal law and with confirmed connections to criminal elements and activity in the Republic of Czechia might be permitted to escape unpunished and uninvestigated with impunity. Only undue influence in violation of 18 U.S.C. Section 206 from the congressional offices of Congressman Beyer and Senator Kaine can explain why Arlington Public School Board member Monique O'Grady was permitted to defend allegations against her political campaign for employing that internet stalker in tortious interference with a business expectancy under the affirmative defense of sovereign immunity, a defense reserved only to agents of the state, and further, to escape punishment for commission of the felony of embezzlement of public monies to defend against those allegations arising from her political campaign in violation of VA Code Section 18.2-119. Only undue influence in violation of 18 U.S.C. Section 206 from the congressional offices of Congressman Beyer and Senator Kaine can explain why, in punishment for bringing those charges in a civil litigation, the complainant not only had a petition of mandamus writ to compel the Commonwealth Attorney Theo Stamos to comply with her statutory duty to prosecute those felonies, dismissed by the Chief Judge for the Circuit Court of the County of Arlington, Judge William T. Newman Jr., but also explain why that complainant was sanctioned for filing that matter with the court by an unconstitutional order, based on no specific legal findings or facts, permanently depriving him of access to that state court, and imposed without even affording procedural due process and an opportunity for a day in court to confront his accusers and rebut the charge. A denial of equal protection of the law, per se. And on Monday, July 8th, 2019, before an audience of over 100 ardent supporters of Congressman Beyer and an event live streamed on social media, he perpetrated acts that show a consciousness of guilt, including false exculpatory statements, by denying publicly knowledge of the allegations that he has even been compelled to defend against in courts, both state and federal. Yet worse, in furtherance of this culpable action, he had his district director, Noah Simon, reject communications to his office intended to follow up on the promise that he, Congressman Beyer, had just publicly announced to resolve the matter. The only remaining question is, how much did a former president know, and when did he know it? The only other question remaining is, how much did a former presidential candidate know about the actions in furtherance of her campaign victory strategy, and when did she know it? But at this juncture, before the courts this week, is the disruption of this criminal enterprise on a motion to direct the Merit Systems Protections Board to commence the investigation it has failed to begin in over 2 years. It is high time to make America great again. And so in November, it is a referendum election where you have the power to choose between the party of manumission, slavery, oppression, Jim Crow, and subjugation, or to choose the party of emancipation. In November, you have the power to choose between the party of welfare entitlement and government dependency, or the party of opportunity. In November, you have the power to choose between the party of underperforming public schools and achievement gaps, or the party of school choice. You have the power to choose between the party of mandatory union membership or the party of a right to work. You have the power to choose between the party of universal socialized medicine or the party that will let you choose your provider and your doctor and your insurance plan. In November, you have the power to choose between the party of awaiting the arrival of law enforcement or the party of the right to stand your ground and defend yourself. In November, you have the power to choose between the party of higher taxes and growing bureaucracies, or the power of lower taxes and self-determination. It is your party and it is your choice. I am a Christian, a conservative, and a Republican, in that order. And I am not ashamed of the gospel. My name is Major Mike Webb, and I am running for U.S. Congress, not unmindful of the future, with liberty and excellence. Let's make America great again. Honest. This advertisement was authorized by Mike Webb.